when it comes to victim services issues. I think because our field tends to have many overworked and underfunded people, it can be hard to fit legislation into your schedule when it comes to paying attention to it and advocating, etc. So that's partly why we're here, but also just Alex is hitting buttons. Just want to give you a sense of kind of what we saw this session. I think every year they break the record for how many bills they request, but they did again this year with over 1,300. The 900 number is how many the drafters for the legislature actually get drafted, because they are not robots and can't do it all. And then of those, a little more than half were passed. We counted 30-ish. We are not going to say that we've got every bill that has a major impact on victim services or victim crime. In today's presentation, it would be 5 days long. Many bills impact victims of crime. I think we followed 140 that had an impact on domestic violence in some way, just because there's so many criminal justice bills in general. But are we getting nailed in?
No, we get to see it from here.
Oh, that's fancy. I thought you were showing us a chat. I was like, I cannot read it.
Like,
But 30 that were more directly related. And then we're not going to talk a lot about the victim services funding today. Hopefully this is old news for everyone by now. But if it's not, we got record amounts of victim services funding. There was large collaboration to do this for the first time. 27.5 million was brought forward. They currently, depending on the way you count it, it's more like 10 million that the state gives from general fund money for victim services in an ongoing way. So this was a big jump, more than doubled in terms of ongoing money, which is about 15, and then 12.5 that is being split out over the next few years. So there's a split for that between sexual assault organizations, domestic violence organizations, and children's justice centers, and then a smaller, unfortunately, amount for other types of organizations and system-based victim advocates. So we're very clear that this is just the beginning, and we have a lot of work to do to get more support and more funding, but it was a good first step. So that's kind of a quick overview of what happened during the session. Related to that funding, I don't think any of that funding would have come through if there wasn't broad agreement on creating a new Utah Victim Services Commission. I know it's going to be confusing for people. There's also the Utah Crime Victims Council. There's the Utah Office of Victims of Crime. Obviously, this commission is really in the statute clearly delineated to look at that statewide alignment, coordination, to kind of continue. The way I think it is continuing. Just looking over here, there's no one sitting over there. Just talk to no one at work. Well, I'll look at these guys over here. It's to really continue the work that that group was doing for the year leading up to last session. Really looking at where's the funding coming from, where's it coming through, are those the best ways for it to get distributed, how much is missing. Legislators are really confused about kind of what the statewide system looks like, what the funding mechanisms are, where the gaps are, and that is not an easy thing. It was not easy for us to pull all that together, and we weren't able to pull it all together. So it's really going to take an ongoing collaboration to figure that out. And so that's what this commission is. It will be under CCJJ. It will have a staff person, maybe two, I think. They will, the chair of that commission will have a voting voice on CCJJ, as does the chair of the Utah Crime Victims Council. So that was one of the goals, is to have increased voices for victims and victim advocacy in that room when it comes to policy decisions and other things. And again, really just looking at what that plan, what the statewide system looks like. I think they'll be working really closely, for example, with what Vicky's role does at UOBC and collaborating with what's already happening around strategic planning. And there's a bunch of people on the commission. So really the way that it impacts you the most, I would say, is to make sure that your voices are heard. It will be the job of those organizations who have a seat on the commission to really make sure they're reaching out to you. I listed on the slide some of the in statute subcommittees of the commission that have to exist. That's really where I think the real work is going to happen, and where we need your voices and your participation. You do not have to be statutorily designated to be on those subcommittees. And so, for example, with domestic violence, it's UNAVC that's responsible for chairing that. UCASA will be chairing one on sexual assault. Someone from the Children's Justice Center Advisory Council or Committee will be chairing for child abuse. So the chairs for those are set out in statute, and then there could be other subcommittees as needed, but stay tuned. As the commission gets off the ground, those subcommittees will be starting and we'll be reaching out and saying, please participate. And we know you're all so busy, so we will also be looking at ways for you to weigh in, give input in ways that actually work for you and not have you going to 27 more meetings. So that's the commission.
My turn. Okay, next is my turn, and we're gonna talk about the online dating safety amendments passed by Representative Romero this year. And the thing that I want you to recognize is that the reason this applies to you, like most of these slides, if you haven't noticed yet, are gonna go through what it does and how it applies to you. Because I think way too often as we jump into this legislative session, people just throw you like, oh, here's a change. We're trying to say, okay, this change matters to you and this is why. And so what the online dating safety amendment does is it makes dating apps and dating websites give a warning to their users saying, hey, you probably shouldn't give your whole name out. Hey, you probably shouldn't give your address. Hey, be aware of financial crimes and these kinds of things. This is what happens if you do get sexually assaulted with someone who you met on our site. And it does better reporting for those and better guidelines for those. The way it applies to you is you just need to be aware that these warnings are going to start existing. Sorry. When you encounter a victim who did get sexually assaulted by someone that they met online, they might also struggle a little bit with the fact that maybe the dating website told them not to do the things they did. And so it may add to the shame they experience. And so knowing that these warnings exist will help you better advocate for the clients as they come forward. Next, we have HB 19, and this is the Rape Crisis Center modification, again, passed by Representative Romero. And this basically defines what a rape crisis center is. And it says it's a nonprofit entity that assists victims of sexual assault and victims' families by offering sexual assault crisis intervention and counseling through a sexual assault counselor. What I do want you to be aware of is it does not specifically include all advocacy. So if you can see on this slide, it does have a citation there, and that's the citation for victim service providers. So remember a few years ago when we did, what is a confidential communicator? What is a victim advocate? What is a system-based advocate? That's that code there. And so just because you're an advocate or your agency does advocacy does not mean you're a rape crisis center. And so being aware of those. I think the biggest take home for this is there was a trend going on in our system, our society of people kind of creating their rogue rape crisis centers. And because we didn't have it clearly defined, it was causing issues and we were seeing victims being harmed. And this also will open up more funding for those rape crisis centers, most likely federal funding. Okay, I'm just gonna fly through this one pretty quick. This is not a new task force, HB number 25. Again, Representative Romero basically just extended the Missing and Murdered Indigenous Women and Girls Task Force and also renamed it to the Missing and Murdered Indigenous Relatives Task Force. The task force has been meeting for a little over a year. I think they've been getting some feedback that it's not just about women and girls, but for those who don't know, it's a pretty significant epidemic in the state where these cases are falling through the cracks, sometimes not getting law enforcement response at all. And then even when there's a lot of jurisdiction confusion based on where the crime occurred, who the perpetrator is, who the victim is, etc. So this task force is really just trying to dig into that a little deeper. They toured around all last year and tried to hit different parts of the state and asked folks to come and give public testimony or public. It is a formal task force where it's recorded and they follow legislative rules, but it's not testimony per se. So I didn't see any upcoming meetings for this task force on the website, but I did put the link on there. If you are interacting with survivors or have feedback yourself
on this issue, just keep an eye on that website and make sure that you can participate online or in person in the meetings, and they really are looking for input on how this issue comes up in your day-to-day work.
We talked about it.
You talked about
Wait,
this?
no.
No, I don't think you did. Earlier, you mean? Oh, you flipped on. Okay, HB 43, domestic violence modifications. This is a bill that had been going on for a couple of years. Representative Rucci was the sponsor. I think, we'll talk about some other bills later that made this, her concerns around this a little less, relevant, but her big concern was, why can no one tell me exactly how many domestic violence incidents are reported, the severity of them, how often children are witnessing them, how often strangulation is happening, some of the things that we know are higher risk, and why, and how can we not match those up, for example, with protective orders and some of those issues with specific cases. I don't have to tell you all that that is not a simple answer, and there's not an easy way to connect all of the different systems that are collecting data in different ways, and especially not connecting them with the same person unless they, for example, applied for reparations or something like that. So this is just a temporary task force that the Department of Public Safety is hosting. Again, they haven't started yet. It should be starting in July. Victim advocates have roles on that task force. Stay tuned. I think UDVC and others will be a way to kind of get that word out to you. There is specifically at least one seat for a system-based victim advocate and a community-based victim advocate. I think there's some others as well. So this task force isn't meant to go on forever, but it's supposed to try to sort out some of those issues and also track some of the new legality assessment stuff, which we'll talk about in a few minutes.
I'm next. We're trying to keep you entertained by flipping back and forth. You don't know what's coming. Okay, anyway, we are on to HB 50, criminal financial obligation amendments. And this bill is a restitution cleanup bill, and it was a result of a group that met with her last summer, right? So we have committees that meet over the summer, talk about issues, and then they come up with a lot of this. The thing I want you to realize with this law is it does two things are really common in this bill as a cleanup. It clarifies what happens in plea in advance cases. So in plea in advance cases, it clarifies that the prosecutor has to speak with the victim and has to speak with UOVC before declaring to the judge that there is no restitution. The second thing it does is it talks about civil judgments. As you may know, we've had more of a common thread of people going after their perpetrators civilly. And on the civil action, if a victim has a civil judgment against their perpetrator, and the perpetrator makes payments to them through the civil case, those payments also can count towards payments in a criminal restitution case if the judge shows that it's connected to the damages done by the crime. Does that make sense? Kind of confusing. Basically, you can't get paid twice for the cell phone you broke. That's basically what it is. My big thing with this is a lot of us are working in justice court cases where plea in advance are super plea in advances. This is important for you to know because this law is new. Do we expect all of our prosecutors to read all the new law every year? No, because I don't read all the new law every year. But what this can do is you can say, hey, there was a change in restitution, city prosecutor. You have to now talk to the victim in your OVC before doing a plea in advance. And that's really important. Next.
I think Alex said this, but please interrupt, ask questions.
Yes.
We're kind of flying through. I'm happy to answer questions along the way.
Vicky,
Vicky,
Sorry, that's on the restitution one.
you have to wait for the mic. You should know.
Sorry, I know, sorry.
thanks. Back on the restitution one, is that applicable only in district level courts or also in justice level?
Refer to my notes. I read that. I believe. Let me verify. I don't have the answer to that. I know I read it, but I can't think of it right now.
That's okay.
I believe it may be just class A's, but
And
above, but I'm not 100% sure.
we'll look it up.
What's my favorite answer?
I can look it up too.
Hey, look it up for me.
Look it up and then tell us, okay? So SB 117, I kind of just referenced this, you probably all heard about this. Sorry, Alex, I'm gonna take a little longer with this one, so I want to make sure that there's clarity around it. So, I'm sure many, if not all of you, know about the lab program, the lethality assessment program. It's been going on in Utah since about 2016. It was never mandatory. It was it was run by UDVC where I'm employed. And it was voluntary. By this past year, we had about half, maybe-ish, of law enforcement agencies participating on their own. It started with a pilot project that the legislature funded. Long ago, the legislative funding ran out, but many of you in your communities have kept the program going, and I think law enforcement and advocates have really seen a lot of benefit from it. Basically, it's specific to intimate partner domestic violence cases. You might get some confusion about that. I think there's some training that's happened that has said that it's all domestic violence, but it's very clear in the statute that it's not. It's intimate partner domestic violence. This bill now does mandate it. It's not something that UDVC ran or passed for. This was really led by the Lieutenant Governor. And the experience that her family had and feeling like if there had been a lethality assessment done, her cousin, who you probably heard about, was murdered by her ex, maybe would have gotten different resources or taken, having her case taken more seriously. So this is really just, it's a huge change, it's a huge shift in the state, about making sure that law enforcement are using the lethality assessment protocol. This bill actually put in the statute, the protocol. I think there's also some confusion around this in that even UDVC is saying this isn't the Maryland model. It's only not the Maryland model if you're calling that because of the different ways that the bill asks the results to be used within the criminal justice system afterwards. The Maryland model doesn't talk about any of that. It's really just about ask the questions for high-risk folks, really for anyone, connect them with services and shelter. What our legislature wanted to do was say, okay, that's great, we want to do that. We also want to make sure that all information about all labs is in the incident report, is in probable cause statements, is put in front of judges. A lot of your jurisdictions were probably doing that if they were doing lab, but there was nothing saying they needed to. And so this bill lays that out a little more clearly, and that's the only reason it's not the Maryland model. The questions are the same. The one difference you'll see is that strangulation or choking is the word they use, is moved up as a high risk, issue. I think a lot of people are already seeing choking or strangulation as high risk, and that actually is changing nationally with the Maryland model to say that we now recognize a yes answer to that question by itself makes a situation high risk. So that might look a little different, but the statute does basically just lay out those questions that you've probably seen for years. There's been meetings happening around the state that Department of Public Safety and UDVC have been hosting. We've been kind of going to the further out areas. Now we're focusing more on Wasatch Front. So, for example, a meeting in Logan on Monday, here in Tooele Tuesday. If you haven't heard about this and are in these areas, I'm just listing them real quick. Provo on Wednesday, Park City on Friday, and then I don't have all the other dates memorized. So DPS is the one sending those invites out to your law enforcement partners. Really, these are not trainings. These meetings are about DPS saying to law enforcement, yep, what you heard is true. This is now required. We are the ones overseeing it and holding you accountable to it. We are the ones who are setting up a system where they have 24/7 SIAC folks who will get the results. They're actually going to look into that victim and perpetrator and especially the perpetrator, to be able to give the officer on scene any other information about what other jurisdictions may have seen from that perpetrator. So there's a really good kind of information piece that will probably take a while to get off the ground. They have an app that they're gonna roll out. So a lot of it is that DPS to law enforcement piece, but we're posting it with them, inviting the victim advocates. No matter what kind of victim advocate you are, you're invited. I don't think those invitations are always getting out in a widespread way. So my email's on the presentation 18 times. So definitely reach out if you don't know about when your community's meeting is. And then I know next week there's also a training, which is more of the training piece on lethality assessment. So it's two different things. Training is really key and probably a priority, but I just wanted, in case you heard about those meetings and weren't sure if they were, who was invited, I wanted to be clear on that. And then as much as it's pretty detail laid out in the statute and is mandatory. It's gonna look different in every community. Some communities have more, you know this better than I do, more or less system-based advocates. They have further or closer community-based advocates. It's gonna have to be worked out kind of how that mandate is met by law enforcement in the way that makes the most sense for both victim advocates to coordinate and for survivors to get the resources they need. So please make sure that you're talking within your communities and then let me know afterwards if you need more information on any of the meetings or the trainings. Hey, just kidding, I'm trying to hand you the microphone. HB 53 protective order amendments. This is one that I think was probably happening in a lot of your jurisdictions, but really clarifies now that if someone's out on a jail release agreement or a pretrial order, that if they need to come back to a shared residence and get their personal belongings, that the victim needs to be notified of that through law enforcement, and then law enforcement need to accompany that person. That is not an excuse for the abusive person to now suddenly be able to contact them despite what the order says. But it just clarifies for law enforcement that that is a requirement now and that they need to accompany them. It also clarifies, and I put up there on the slide, the timeline for when those two types of orders expire. You might have to go back this morning and stuff like the order stuff. So with this one, what it means for you is just making sure that your law enforcement partners know about this. Again, you've probably seen them doing this already, making sure victims know that that's still a violation. If they're hearing directly from the person, that should go through law enforcement in order to not be a violation, and that they have that option, that they don't need to let that person come without law enforcement there, and then they need to be given notification that that's going to happen. Okay, we're gonna skip workplace protective orders. You did talk about this one. Yeah.
Oh, I almost dropped the mic, literally. Okay, next we're talking about HB 509. This is criminal protective order amendment. This was a bill that came out of one of Crystal's cases, because as you remember, like a few years ago, 2019, if I remember correctly, our protective orders got completely revamped. We went from 10-year civil protective orders down to 3, stalking injunctions went up to 3, like it all just changed, and we were like, what, right? Well, part of that change was adding the continuous protective orders, which we talked about a little bit this morning, and the fact that when we were in this work group, we said, if you're going to make the civil protective orders go down to 3 years, then you need to give us another way to kind of protect victims. So we came up with continuous protective orders. So we got this new great order, but we learned over the last year that defendants can ask for it to be removed, and there was no requirement to inform the victim. There was no requirement to have a hearing. And the judge could just sign off on a motion to get rid of the continuous protective order. So what this bill does is it gives us a little more language. It requires that the prosecutor try to inform the victim with reasonable effort, and that there has to be a hearing. What this means for you is I really want you to pay attention that that reasonable efforts are going to be subjective to the prosecutor you're working with. A reasonable effort may be a phone call or an email to the name on record, right? So it's even more important that you communicate with your victims to make sure that the email they gave the prosecutor never really goes away. Or if it does, that email needs to be updated with the prosecutor. Making sure that the courts have their right email or phone number. So if these things are requested, there's contact information somewhere so that this victim can be informed. Because it will be quite traumatic if you thought you had a continuous protective order, and then you find out 6 years later that you haven't had it for 4 years, right? So this is a part where us advocates really need to be informed that the only way they're going to get informed of these hearings is if their contact information is up to date with the prosecutor. Is there a question in the chat? No, okay. Okay. Next is 511. Passing the torch.
Okay, 511, Representative Carucci's crime victim identification amendments. This is something that I think a lot of people thought was already a law, but was not. So basically, it prohibits law enforcement from disclosing to the media, and it in the statute, it specifically talks about what media means. It's not social media, it actually says the word bona fide, which made me laugh. Bona fide newspaper, et cetera, et cetera. The name or personally identifying information of a minor victim of criminal homicide. So someone in Representative Carucci's district had experienced family members not hearing about the murder of a child in their family until they saw it on the evening news. And so making sure that law enforcement is not releasing that to media specifically. And it's kind of like what Alex was just talking about. It says unless and until they made a reasonable effort to obtain consent from the parent or guardian. So again, reasonable is somewhat subjective, but I think it at least gives notice, especially to public information officers as well, that they need to make sure that they have consent from the parent or guardian before we release that. The parent or guardian who may have been involved in the criminal homicide does not have consent, so it has to be a different one than that person. Oh, so how this matters to you, sorry, it's just letting victims know, and their families know about the protections, and then again, making sure your law enforcement partners are aware as well.
Back to me. Now we are on Senate Bill 15, which is the Juvenile Offender Penalty Amendment. This was another cleanup bill. So to talk about this, let's talk a few years back. We had the juvenile justice reform whole thing going on, right? And everything kind of changed, the system changed, I let a lot of kids out. And it's doing so good from what I hear. But part of that is we created an issue. So we have severe cases, right? So we have juvenile offenders who commit the most heinous of cases, and we do things like bind over the case to adult court. Does that sound familiar to everyone? Yes, no? If it says no, I'll explain it, so. Okay, I'm explaining, I just don't want to be redundant, okay. When a juvenile is over the age of 14 and does a serious felony offense, I don't remember exactly what is serious, but it's usually like homicide or aggravated rapes. And the prosecutor says this is a heinous crime, the prosecutor can then choose to show the court that they want to certify this kid as an adult. And that certification process takes the kid's history, the kid's information, this kid's evaluation. It says, hey, judge, this kid had many chances. This is really heinous. We want to try them as an adult. The judge says, yes, you bind the case over into adult court. The other way a kid can get into adult court when they commit the crime as a minor and it's serious is they can do a dual plea. And a dual plea, I'm just going to give my case example. Kid was charged with attempted homicide, aggravated sexual abuse, aggravated sodomy, aggravated rape. That was the charges. There were more, but that's what I remember. And we said, okay, in juvenile court, you're going to plead to the aggravated sodomy. And then you're going to stay in juvenile care until you're 21 to give you the skills you need to be a successful adult. But we're also going to have you plead at the same time to aggravated rape in the district court, because this is such a heinous case. We feel that you need to be incarcerated for a long time, but we don't want to throw you in at 15 because you'll be in solitary confinement. So we do this like that. So it's like you have a case in juvenile, you get sentenced in juvenile, and you have a pending plea, but the plea agreement has been entered in adult court, but you're waiting to get to sentencing until the person's 21. Hope you're following. I know this is complicated, but we're all going to have one of these cases. Well, the reason we have to explain all these cases is because in the juvenile fix that they did, they put in a 7-year cap. They said juveniles cannot spend more than 7 years in custody, period. There was no exception, it was just period. And so what that meant was, so in my case, where he was in juvenile care until he was 21, he would be let out. And it was a horrendous case. It was the Sandy Jogger case. Vicky knows. It's her case too. And so when this law came about, defense attorneys started saying, hey, look, we have a 7-year cap. We're going to ask for him to get released now. And we said, oh, poof, with more swear words. And then we went to the senator who passed the original bill, and she was a House representative at that time, and said, hey, this is a problem. And so we ran this fix. And so this fix says that on the most heinous cases, you do not have to have a 7-year cap. You can go beyond that, but it has to reach this. Why is this important for you to know? You all are gonna have some crazy juvenile out there who commits the most heinous crime at some point. Understanding that there's a difference between juvenile court and adult court, how these systems work together, and what sentences could be possible is really important. So you need to know when these cases come forward, can this kid spend more than 7 years, or are we lucky if we get 7 years? Right, so that's the take on this one. Oh gosh, this is me. Okay, we're gonna have fun with these ones. I have to set this down. There's one right there. Okay. So you guys all remember the summer or the beginning of legislative session, you probably got an email from me, or someone you know got an email from me, panicked that victims were gonna be forced to go sit in depositions before prelim. Does everyone remember that? Okay, so you all have PTSD like I do, because that was traumatizing. Well, after the great fight that you all did with us, we submitted letters to, because I made lots of people listen to me. We submitted a big 6-page letter to all the senators and House representatives with 94 signatures from people, from prosecutors to police officers to agencies, saying this isn't okay, please listen to us. And that put the bill on hold. Senator Weiler went on the floor, gave a big, oh, there's Paul. That's
Really quickly explain why the claim was, like, where was it coming from?
This was coming from defense attorneys saying over and over again that we're having just paper prelims, which paper prelims are our 1102 statements, and that defense attorneys need a chance to cross-examine the victims, and they need a chance to basically attack the victim's story to know if they should accept a plea deal or not. But they didn't. In my professional opinion, they were saying we need a chance to go after the victim to kind of discuss whether or not we should advise our client to take a plea deal, or if we should advise our client to push to trial. Which in some ways I can see their perspective, it's their job, but making a victim sit through a deposition would have been very horrible for them, and it would have caused more trauma. So we have 2 bills. We're going to talk about this one and the next one. So after that big fight, Senator Weiler pulled his bill and said, well, I want data. Give me data, and then I can argue this later. So what does this bill do? And we're going to collect data on the number of Class A's and felonies. We're going to collect data on the number of cases that go to preliminary hearings. We're going to collect data on the median and the range for preliminary continuances. We're going to collect data on paper prelims, as we know, 1102 statements, and testimony and paper prelims, like the combination, and only testimony prelims. So we'll see what it says. What?
I was allowed to jump in. I'm so offended. I will just say that one of the things that happened in the many months of negotiation on this bill was that there was a lot of anecdotal stories about the victim who was making it all up, and therefore the defense attorney didn't have a chance to question them. They were going to pleas or trials for no reason, blah, 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 blah. There was also like Salt Lake County could give us data, the courts could give us data, but there was all these claims about how many 1102s were done without the victim filling out themselves. That how many prelims were done and what the results of those were without good information about those. So I think not that we won't have to continue this fight, but actually having real numbers and not just basing it on whoever can tell the most emotional and horrifying story in the conference room with Senator Weiler, I think will help us come up with if there even needs to be a solution. I think that was the real issue, is the prosecutors and victim advocates just could never come to an agreement with defense attorneys that this was a problem that even needed solving, that they felt like there was plenty of ways for defense attorneys to get all the same information that the prosecutor and law enforcement had about the case, and so that this wasn't needed. And I think that's kind of where things got stalled, and having this data will help.
She just stole my points of how this applies to you. Good job. That's great. But I also think this data could be great for us to start advocating to say, hey, our cases are taking way too long. Our cases are getting really light sentences. They're being charged with a felon, a first degree, they're pleading out to class A's. So if we're paying it, if this data really comes to be as great as I hope it could be, it could be used for a lot of good on our end, and also a great point where we can have a fair ground negotiation with the other interests, the defense interests. So that goes into the next part of which is the second bill that these two are working together. So this is SJR is a Senate joint resolution. And the reason it doesn't say Senate bill or SB is because we're changing the rules of evidence. We're not changing the law, if that makes sense. So that's why it has a different title. The rule we are changing here is the rule of criminal procedure regarding preliminary hearings. This is the one that you all need to know and need to figure out how your agency is going to implement these changes. So what this says is that a prosecutor may help a victim draft their 1102. So everyone know what 1102 is? Raise your hand. Okay. We got some. So 1102 is the statement that a victim can fill out. So it's like a sworn affidavit, like, I swear I'm not lying, perjury penalty law. Here's my statement of what happened. And then they sign it and they give it to the judge and say, hey, judge, here's an 1102 statement instead of my victim coming to testify. That's what the prosecutor will say. That's great. It helped us during COVID. Otherwise, the courts probably would have never presumed if we didn't have these during COVID. But the argument from defense attorneys is they're being abused. So the changes to the 1102 rules state that a prosecutor may help a victim fill it out, but they may not fill it out on their own. So what some agencies were doing is the prosecutor would send it to a legal secretary, and legal secretary would basically write what was in the police report and a statement, and then the victim would get handed 2 papers and would say, hey, you either sign this or you show up to court, which was also traumatizing. I didn't agree with that. I made that clear. But this says it has to be more of a proactive thing. So a prosecutor can't just write it on their own, like the agency can't write it on their own, but you may assist a victim. How agencies are interpreting this now is we're just not touching. So there's some prosecutors who are saying, I'm not touching them, I'm not addressing this, we're just going to go back to testimony prelims. And other agencies are like, we'll just follow the new rules and invite the victim in for a meeting and help them write it. The reason I want you to know this is because you as an advocate can be the one to help the victim write the 1102 statement. I have done it, you can do it, you can do it, you can do it. Just bring your victim in, create a protocol within your office of how you do it. What I do is I will print the probable cause statement with the charges, and I will say, the first count is this. This is what the court's probable cause statement says. Tell me what happened. And then my little fingers just do dances. And they go, go, go. And then I say, the next count is this. This is what probable cause statement says. Tell me what happened. And I just go, type, 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 type. And that gets it done in a trauma-informed way because you're helping them tell their story. You're not sending them a statement that just says, these are your words, right? Sign it or get on the stand. So you as an advocate, or do it by yourself. It's better if we're assisting them. So you as an advocate can take the initiative to go back to your districts and say, how are we doing 1102s from now on? And how can I help set up a protocol that obeys with these new rules? And I would encourage you to do that because I'm not loving the way some of this is getting interpreted across the state because it is a fear-based approach right now, because it was a real attack on prosecution. Any questions on that? That was a lot of words. No? Okay. Victim services.
I think the after lunch slot is so difficult. Wake up. Should we do jumping jumps? For the people online. You are going to. Okay. HB 297. This is a complicated bill. You may have heard about it. Representative Bergman is a sponsor. There was a lot of media coverage on it, a lot of media coverage from her sister about this legislation going into the session. It was messy and lots of drama. victim advocacy organizations, I can't remember what the Crime Victim Council's position on it was, but for both the UDVC and the Sexual Violence Policy Alliance, Alice will talk about that in a minute, I never remember all the words. We were both monitor on this bill because it does good things, but how much it does the concerning things was kind of a debatable question. It's a really complicated bill, but we wanted to give you a sense of it. I don't know that it's going to change your day-to-day work that much. A lot of the things in it that we like, I think were already happening. Maybe they weren't in the law, some might argue they were already in there and we didn't need this. That happens a lot on the Hill. But what it does is that the sexual assault hotline, so this is specifically the communities, organizations, as well as the state hotline that we also run, they are allowed to inform victims how to access free emergency contraception. Again, I think that was probably happening for the most part. What was originally in the bill was also requiring the State Department of Health and Human Services to provide that free emergency contraception. I think that would have been a much bigger change and bigger newsflash, and we would have had billboards, but that was taken out because of funding, which often happens in these bills, and then you wonder, what does this bill still do now that there's not funding attached to it? But it does say that about hotlines. 2 years ago, when a number of abortion restriction bills passed, and some last year as well, there were rape and incest exceptions in the statute. What this bill did was to clarify that those rape and incest exceptions go away after 18 weeks. So it doesn't matter if your pregnancy was a result of an offense or an assault, abortion is still prohibited after that 18-week mark, which was previously, the 18 weeks was previously the law anyway. So that's important when you're talking with victims about options. One thing it does that I think is interesting, and it'll be really interesting to see how this impacts the fund and whether people are accessing it and what it does to other victims who might now not be able to access resources. But it basically says that if you are someone who became pregnant as a result of sexual assault, healthcare, and you have the baby, you get your healthcare paid for through CVR throughout your pregnancy, and then you're eligible for assistance for both you and the child for 1 year afterwards. I don't know how that's all going to play out and how expensive that might be and how often people will really access those services, but I think that's where you come in terms of making sure that people are aware that that's out there, because it was a huge political talking point, was that if we're going to say you no longer have that option after 18 weeks, the legislature was saying, well, look, we're going to help them and give them support. And so I think, as you all know, you can pass as many bills as you want, but if those of us working on the ground aren't implementing them, then it doesn't matter. And so I think that's where we come in terms of, as well as saying nurses and other folks, to let people know these resources exist. The next two pieces, I think, exist in a lot of agencies, but it does require that law enforcement undergo training on sexual trauma and sexual assault investigations, as well as having policy around public information, reporting, et cetera, for the sexual assault cases that they are seeing in their agency. This was really a lot of talk about how many rape kits were being tested or not, sexual assault cases that were not being prosecuted or investigated even. So I think this was language to put in to try to say, here's some other ways that we're trying to help sexual assault cases go more smoothly in the state. So again, making sure that you know about those options and resources for victims, maybe reaching out to your community-based organizations who are running those hotlines to see exactly what they're telling folks. If you're getting questions or confusion around that, and then again, I feel like every slide was make sure your law enforcement agencies know about this, because so much is about new requirements that they have. But this is another one.
Okay, we are having an argument because both of us did not want to do this slide and I got stuck with it. So the sex offender bill she did right at, I'm presenting it. We're kind of running out of time, and this is a lot. You guys all have these slides. I think the biggest thing is what we're realizing is there's a whole, every year someone is passing some sex offender registry bill, and there's some changes, there's inconsistencies. We have solicitation of a minor is longer than other crimes. So like, it's just a mess. And so the best thing that came out of the session is Representative Stoddard created the sex offense management board. And they just closed the application process for the boss of that. And so I think we're gonna see probably more changes coming out of that. More evaluations on what's equitable, what's inequitable, what's working, what's not. And so I would say more or less pay attention to what's coming up. And read this slide because we're running out of time and it's so confusing, so. But Erin wants to interject with that. I do.
I chaired a similar board in Colorado, and I would just say, as we get this off the ground in Utah, your voices are so important. I think we just kind of assume like, oh, the treatment providers will be on that, and the therapists will be on that, and attorneys will be on that. But I think it's really important that you as victim advocates, that your voices are there as well, because especially when it comes to sex offenses, there's a lot of research out there that will probably heard it around sex offenders have the lowest recidivism rates, that some of the ways that we've treated them in the law and in registries and in prison sentences does not reflect the research. If victim advocates' voices aren't there saying, what do you mean by recidivism? Do you mean that victims aren't reporting any more crimes from that perpetrator? That doesn't mean they're not happening. Just, and it's not, I'm not saying all the research is bad or that I fully disagree that we need to look at some of the registry stuff and restrictions, but having the voice of people who are actually working with the victims of these offenses, I think will be really important. Okay. Similar to the sex offender bills, there's always a slew of firearms bills. We tried to pull out the ones that we felt like were the most relevant to you all. I've heard as we've been going around state giving legislative updates that probably most of these are not going to be really impactful, so that's why we just spent them all together. But really quick, a lot of prosecutors said this wasn't needed, but Representative Elizabeth ran clarification that misdemeanor DVs make that the offender firearms restricted. I think that's the part that people were saying that's already the case. But if that charge is expunged, pardon set aside, or reduced to an infraction, then they would no longer be restricted to firearms unless that order expressly prohibits them from accessing firearms. So that might be important for you to know in your cases. The next one, HB 199. This was an attempt to do a lot more around making sure that if someone has voluntarily relinquished their firearms for themselves where they're cohabitant, hopefully you already know that that's an option for victims that are cohabitant. What I hear is that most victims, not in a million years, are they going to relinquish the firearms of their abusive partner because they know how much that can increase the risk to them. But if they've relinquished those voluntarily, or the perpetrator themselves, miracles relinquish their own firearms temporarily, that law enforcement needs to do a background check, make sure that they're not a restricted person before returning it, because we only have the voluntary relinquishment piece unless the firearm is evidence that law enforcement has taken. We only have voluntary, so before this law, you could just walk in and say, I gave you these firearms, I want them back now. Now it says law enforcement needs to at least make sure that you're not a restricted person before they give them back. And that there's more information given to victims about voluntary relinquishment. Period. I don't know what I was going to get into that. Next, you want me to hurry up. Next one is HB 225. Similar but different. So as I just referenced, when law enforcement can take firearms is when it's evidence in their case. You all know that. Now, again, once they no longer need that evidence, if that person comes to retrieve their firearm, it will now require law enforcement again to run that background check. Probably think that many agencies were doing or that people thought were happening, but just making them clear. And then the last one that we wanted to highlight was HB 435 around restricted persons. I think there's one of these bills in every session to make sure people have the information. About how do they not have the information right now? But yet again, we are requiring that if someone becomes a restricted person, that they are verbally informed when they're served with a pretrial sentencing or protective order, and then that they must sign an acknowledgement that they were informed and they understand that they're a restricted person. More of those in bills. Any questions in any of those? Don't let Alex intimidate you because she's Russian. You can have questions. Okay. Not just me.
I hate firearms. Just kidding. The next two we want to talk about did not pass, but I wanted to highlight them, especially because I wanted to emphasize the importance of collaboration with our agents. So as you can see, there was like last summer, there was the case in Arizona about the LDS church being sued, not protecting kids, right? Big issue. Utah was like, hey, we've been trying to pass a child abuse reporting exemption for years. And then we said, we're gonna try again this year. Guess what? We failed again. Problem this year was that we had 3 bills. One was did nothing, and so I didn't highlight it. And the next one was Representative Romero's, which completely got rid of the exemption for clergy privilege altogether. The second one was Senator Pitcher's, which would have been more palatable, saying, I have to read it, so I won't remember. Clergy exemption if they believe abuse is ongoing or likely to occur again. I thought Pitcher's was a great compromise and a great first step. What we ran into is not a lot of agencies were willing to say something is better than nothing. A lot of people wanted to say, we want the whole caboose. As you know, we don't get that legislative work. You get part of what you want and hope to get more later. And so why I'm bringing this up now is I want you to know is if this gets brought up again next year, you need to be active in the sense that you want this passed. We all know this is hurting kids. But we also know it's important to have clergy privilege so people can trust their clergy and stuff. So be vocal, go to these policy groups, voice your opinion that you're happy. And if you don't have my opinion, something's better than nothing, well, voice that too. But having an active voice in these systems is how we're going to get change. Because way too often, the victim's voice gets muddled. The victim's perspective gets muddled. And then we end up back with the politicalness of we want to keep clergy privilege, and it looked good in the news when we all stood up and said we were going to draft a bill. But again, these bills don't actually comply. So no, it's not law. That's the biggest thing. No, it's not law. And be active in next legislative session to the best of your ability to advocate for the things that would help your clients. Okay, we need your voices. Right on cue. We have 2 policy groups that, well, we have the Victims Council as well, but for specifically sexual assault, we have Utah Sexual Violence Policy Alliance, which is ran through UCASA. And Danica Baird is the contact. That's her email. She does this in her free time. She runs this group. And she's on UCASA's board, so email her to get part of that group and attend meetings and get updates. And then Erin is the other one. I'll let her talk about the other 2.
Right, so UBBC also has a public policy group, kind of what Alex was just talking about. I think is important to know that victims' voices get muddled in my experience because, shocker to you all, victims are not a homogenous group who all want the same thing or believe justice is the same thing or have the same opinions on pretty complex policies. So these groups are where we're really able to have confidential conversations with one another. UDVC's public policy group is open. Just email me and I'll send you the responsibilities. We do ask you to sign off on some standards in terms of confidentiality, et cetera, but then we meet once a month for 2 hours. Leading up to the session right now, we're really talking about what are bills that are coming up, what feedback do we have about them, what are issues that we want to bring legislation forward on, which from some of those conversations is where the lease termination bill that we're going to talk about in the next presentation really came from. So we need your voices there, we need you to participate. And speaking of, there is a specific issue that I want to make sure you're all aware of. I think Maddie did or will put the link in the chat for me. She's giving me thumbs up. You wrong. To a bill where we're trying to really understand how frequent the issue is around one co-owner of a home allowing potentially dangerous people to come in the home against the other co-owner's wishes, and how that kind of can become an abusive situation or be part of existing abuse. And some of the feedback we've heard around whether law enforcement can do anything about that because they're closed or something. So survivors have come forward about this. Senator Carmore is working with us, but wants to understand how big of a problem this is, what are the nuances of it, what are you all seeing? And so this is a very fast survey, I promise, just to get that sense. Are you seeing this? What does it look like? Do you have ideas about this? So we'd love for you all to fill that out and then again, get that out to your officers, people you're working with. Rochelle's gonna put it in our Friday email tomorrow as well. We'd love your input on that. As well as the Crime Victim Council, we meet every week during the legislative session. Those are open meetings as well. I'm not a member of the council, but I go to all those meetings during the session. So we'd love for your input to be in those as well. And folks at UBC, et cetera, probably be the best ones to get you info on how to get the notices up. Yeah, let's take a quick break to just transition.
4 minutes.
Okay, 4 minutes. I think we can do till 2, well, now it's 2:06, 2:10, sorry, Alex is making it be 4 minutes. For us to start, we're gonna delve more into a bill we haven't even talked about yet, but we're gonna spend a whole hour on it, lucky you, on these terminations. So take a quick break and then we'll be back to talk about that.